Mr. Kramer.
Morning, my lords. Yes.
Sorry, go on. Can I check at the outset, have you agreed between yourselves a timetable?
Yes. I'm going to come to that in 1 minute.
Yes.
If I may. I appear with Mr. Mathewson, and we have Mr. Stewart and Mr. Folkard. Mr. Mathewson's going to handle our interest appeal a bit later on.
Yes, I see.
We appear against D1 and D2, but Mr. Stewart and Mr. Folkard only appear for D2, that's Stevens and Bolton. D1 is in prison, that's Mr. Patel, Mr. Girish Patel. He is not represented, he does not appear. The first appeal is against him, other than the interest element. The cross appeal that does not involve him, he makes no appeal. The position, as I understand it, is he has all the documents. There's one detail on that I'll come to. We prepared separate appeal documents for him because his appeal is slightly different in very minor respects, especially that we don't appeal the interest against him because it doesn't apply to him. And there's a separate, in section C of the core bundle, there's essentially the same documents you have earlier on, but just track changes showing very minor differences. He has had those documents. He has indicated, I think, through his prison amount to the court, but we've seen it, that he doesn't want to appear and he's put in no skeleton. And so that's the position that D2 will be arguing the points. They will, to the extent that they apply to him because they're about quantum only. The wrinkle is, I understand there's an outstanding extension of time for service application. My junior may need to deal with it if we have to go further, but I understand we did get an extension of time to the 5th of July. We were trying to track down which prison he was in. That took some time. We did initially serve him, I think, in Wandsworth, but then he was moved, I think. But ultimately, we found where he was, which is the Mount, and served him on, I think, the 9th of July. But our previous order only extended time to the 5th, and for good order, there's an outstanding application to extend to the 12th, which we therefore still press just to ensure that our service is formally valid. No one's taken any point on that, and as I say, he's communicated through his prison, so I don't think there's anything more to say about that.
I don't think we need to rise to discuss that.
We will have any minutes if we should extend time.
We will indeed extend time.
I'm grateful.
And in due course, can you make sure that that's reflected in the order ultimately made?
I'll wave my hand and those people will do that for me, my lord, they'll remind me. The bundles you have, there's a core bundle and there's a supplementary bundle, and there's, I say A, I think the core bundle may be divided into two, and there's an authorities bundle that's, I think, is also divided into two. That's consolidated through both appeals, as are all of the bundles. There's 3 skeletons. There's a skeleton from myself on our appeal. There's then a consolidated skeleton from D2, which is responding to our appeal and making their appeal, and then we have a respondent skeleton to their appeal. Hopefully you have all of those. I think there's been a further short document from Mr. Folkard in relation to interest that we'll come to later. I think it's a diagram. I think that's the only other document that's come in. As to order of play and timing, we're in your hands. Mr. Stewart and I have spoken. What we had, so we have 2 days as I understand it.
Yes.
What we had proposed is that I will open our appeal, that's the Barrowfen's appeal, and that will probably take half a day or slightly more. And then Mr. Stewart will then respond to our appeal and also make his own appeal, his cross appeal. And then I will respond to his appeal, and then he will respond in reply on his own appeal. So, sorry, I will respond to his appeal and reply on my appeal, and then he will have the last word on his own appeal, and that we would broadly chess clock it and just divide, make sure we only use a day each, however we wish to divide it. Now, there's the wrinkle on that is that there's an outstanding point which comes up when we get to the cross appeal as to whether you hear it at all, and you'll see the way the permission is put. I don't know if I wanted to speak to that.
Think whatever the ultimate decision as to the scope of the permission, we would want to hear full argument.
My lord, that's helpful. So therefore, that's how we would propose to divide the 2 days. The alternative would be to do one appeal in full and then the other, that provides less flexibility on time, because I think that the cross appeal probably takes up less time. So that was our preference, but it's much
And you'll feed interest into that
Yes.
overall picture.
Sorry, and I won't forget Mr. Mathewson next. So he will come in our appeal, so he'll come at the end of my speaking this morning, or
Yes. That sounds fine.
I'm grateful. So on to our appeal, which I open. This is a quantum-only appeal. The issue could be formulated in different ways, but it's a pretty simple issue. Should the respondent, well, the appellant here, but should Barrowfen, the defendant, have to give credit for the notional capital value of their land and the completed property development just because they could, underlined could, have sold it all, even if, which is not disputed, they did not intend to do so, had no plans to do so, and did not do so, and instead planned and are holding it as an income generating asset. There's a rider to that issue, which is when should that credit be fixed, according to the judge and Barrowfen, sorry, the claimants and defendants. According to the judge and D2, that should be fixed at the date of completion of the development, not before, not after. So that's what the judge held. So should you have to give credit for that notional capital value? You could frame it in other ways. Two other ways are, is there a legal principle that prevents the claimants recovering their actual losses in this case, and because the development is not being sold, the land is not being sold, it's not disputed that that's what's happening here. And if so, what is that principle? Or finally, when, if ever, is it treated as a speculation that breaks the chain of causation for a claimant not to sell its whole business? Now, Mr. Stewart might say those are tendentious ways of putting it. Of course, they are, in a sense, but that's the way we see the issue and what happened here. If we win on this appeal, there are consequential appeals about interest and cost parts of the order, but it also happens that our interest appeal would go away and Barrowfen's cross appeal would go away, because that cross appeal is about how you apply this credit that we say should not be applied. My lord, just to signpost you a little, I intend to talk first about background, then about number 2, about the business of Barrowfen as holding the land and its property long term for revenue. Number 3, I'm going to talk about the 2016 to 2021 non-breach position, so the lost rent during the delay. Number 4, I'm going to talk about the 2016 to 2021 breach or actual position, so what actually happened. Number 5, I will then talk about 2021 onwards, which is where we get to whether and why and how you credit the credit. And that will be as a matter of principle. And then number 6, I'll talk about the judge's reasoning for disregarding the finance figures in applying the credit that he did. And number 7 will be the law and the cases as applied to these facts. My lord, just on background, first of all, how we got here. So just before I get into substance, I want to explain how we got to this position, which is a judge with a careful judgment, 322-page judgment after 15 days, made what we say is an error of law. It was because the issue arose in an unsatisfactory way. This court, I think, will not infrequently have to pick up the pieces where things don't arise in the cleanest way in a trial, and we say this is one of those cases. The gist of the chronology, and I will go to some of these documents later, is that D2 proposed a draft amendment pleading...
Just before you do,
sorry,
why does it matter? how we got where we got. I mean,
Well, it will help you to understand the difficulty. I mean, I can jump forward to the judge's explanation of how we got here if you'd like, my lord. But essentially what happened is the judge at the trial decided the issue of whether there should be a credit of capital value, but put off the highly connected question of whether that credit should take account of finance costs going forward. And he put that off because he didn't then have evidence about those costs because the amendment had been made during trial. And if we go, and my lord might have saved me 10 minutes, so I won't complain about that, but if we go to CB Core Bundle tab 20, page 611, this is an approved note of the extempore consequentials hearing. And we'll see at the foot of the page under the heading, so this is page 611, foot of the page under the heading Permission to Appeal, he granted permission to appeal his own judgment. He said there was a real prospect of success. And he also said the arguments at the trial and the reserve matters hearing would have also been better dealt with together, if heard together. He is satisfied he's correct on those issues, of course, or else he wouldn't have decided what he decided. He says there's a real prospect. And then he says that further, he takes into account the fact there's been delay between the trial and that delay is an issue. And then in the final 4 or 5 lines over the page, the way the issue arose has to be taken into account. He says, I might have decided the issue differently if all the matters had been heard at one time. There's no challenge to the case management decision, which is correct. There's no appeal against the permission to amend, etc. And then just to finish what he says, that's it. Tab 22 is the N460 form. And you'll see at page 616, at the top box, he says there's a real prospect because C always intended to keep the property as an investment and not to sell it. And it could be said, therefore, this was a notional increase in capital value. So he's accepting that he understands he's effectively deemed a sale or a crystallization of capital value, even though there wasn't one and there wasn't an intended one. But then at the bottom of the page, he also says, more unusually, that there's some other reason. He explains that the issue is taken just before trial. He granted permission on the basis that he'd give an opportunity to obtain further evidence, which happened. He says, I cannot be certain I would have granted permission if I'd known how this issue would develop and expand. Cannot be certain I'd decide the point in D2's favour if the claim to be able to deal with the entire case at the same time. I am confident I would have done so, but C suffered a procedural disadvantage. So this is about as clear as an indication as you can get that it didn't come cleanly to the judge or entirely fairly. Now, of course, we have to assess the merits of the argument on principle of law, and he could be right and he could be wrong. But I just want you to understand how we say that a judge who normally you would expect to have got everything right, because all judges normally do in the sense that it's a very careful judgment that goes through most of the points very carefully, had to decide this point in 2 parts. My lord, just by way of background, I don't need to do much on this because this is a quantum only appeal, but just to remind you, and I assume, my lords, you've read the skeletons and hopefully at least skimmed the long judgment. The core of the liability that founds the damages claim is that the defendants were responsible for delaying the property development at the Tooting property, and indeed D1 is in prison largely for a fraud on the same facts as I understand it. The detail of those is not important. There was a hard-fought trial with disclosure of privileged documents because of iniquity and all sorts of things. But just to see a summary of the conduct in the trial judgment itself, which is at core bundle 18. And if my lords go to page 431, we can see, sorry, page 549 of the bundle. It's, am I right? Sorry, page 431, that's right. 549 paragraph. So this is under the heading of negligence, conflicts of interest. That's one of the details, which I'll then come back to. But there's an example there of how essentially what happened is D2 didn't deliberately ignore a conflict and prefer the interests of one family member over another over the company, but ought to have appreciated the conflict. And it's difficult to think of a more obvious conflict. And then you can then see a more general summary, which is at page 485 of the bundle. And that summary is paragraph 699 to 708. And my lords could perhaps skim that to themselves, they would have seen it. The gist is that although Girish Patel was responsible for dishonesty and breach of fiduciary duty as a director, D2, Stevens and Bolton, were liable only for negligence in essentially failing to realise conflicts of interest and to protect the company from the improper actions of one director. And there was a huge amount of factual evidence and argument and cross-examination that even but for the breaches, Mr. Girish Patel would have ignored the solicitors and gone on and done what he did, and that was rejected on the whole, and there's no challenge to those causation findings, or because of the dismissal of ground 4, for which no permission was given in cross-appeal, there's no challenge to the percentage losses of chance, which become more relevant in the cross-appeal. My lords, on the property, which is very important.
Where is the best summary of the percentage, or are you going to come to that?
I'm going to come to that, yes. In fact, we're going to spend tomorrow on it. But yes, if my lords want to just to remind you of it, the simplest place is actually in a diagram, but we can forget about that. Well, perhaps I'll come back to that later. I don't want to click through pages now. The gist was that there's a 60% chance of that, but for the wrong, the development would have got going in 2015 and finished in 2016. In the contrary world, which is the remaining 40%, had that not happened, further breaches, had they not happened, there's then an 80% of that 40%, which is 32% chance that the development would have commenced in 2016 and finished in, I think, 2018 and avoided administration. And then there's a residual 8% chance that even if the defendants had not committed their wrongdoing, still, at least as regards Stephen and Bolton, still the company would have gone into administration and the delay would have happened, and so no loss in that situation. So that's the 60, 32, 8. And those will become very important on the cross appeal, and I'll show you them perhaps when we touch them in the judgment a bit later. My lords, just on the property, if we stay in the main judgment and go back to page 229 of the bundle, so it's quite early in the judgment. My lords will see.
Did you say
229, paragraph 22.
Sorry, so that's a different folder, so you just need to
it should be the main judgment.
Yeah, the main judgment is unhelpfully split between the two folders.
I'm sorry, my lord.
Certainly.
I reprinted mine double-sided, and that's
Yeah.
not the case.
Right.
Apologies for that. So at paragraph 22, we see that the claimant company is owned by members of some Malaysian family trusts. Originally, as it's mentioned, there were multiple families, but by 2002, it was just this family, the Patel family. And then as to the property, if you go over leaf to 25 to 6, paragraph 25 to 6, we have the Tooting property, which is the sole asset of Barrowfen. And most of the facts are recorded there, but none of them are disputed from that it was acquired in the 80s, I think 1984. Its development was still being being planned in the noughties. That's elsewhere, but our skeleton 15 cites it, and then you see here that the business plan here was to buy the land. Buy the land. The land was bought in the 80s, so this is a long-held piece of land, and I'll come back to the fact that it was actually already drawing rental income for many years. But then it was going to be redeveloped in order to improve that rental income, and held with improved rental income. There's no dispute about those facts. But the key point from these paragraphs is it was existing land. This is not a developer who buys land, develops it, and flips it for a profit. This is a family-owned company that has one property. It's had it for decades. It's drawn income on it. It's become dilapidated. So it seeks to develop it to improve that income. That's the context from which one has to decide whether it's speculative for it to not sell the whole property that it's held since 1984 in 2021, which is essentially what one would have to find to justify the judge's conclusion. We'll come back to that. But
I think that's disputed.
which
I
part?
mean, you assert that, but I think that is.
It's disputed as to whether it's speculative. That's the core point, but I don't think there's any dispute as to the intention to hold and all
No,
that.
it's not disputed that that was at least the intention of the company.
Yes.
But the question is whether, as it were, the company can say, well, we're entitled to continue to hold it, come what may, irrespective of what cost that is, in circumstances where we could sell it or remortgage it, and reduce the finance costs or eliminate the finance costs. I mean, as I understand it, the argument is that
Sell it.
there are a number of ways in which you could put an end to the liability for the finance costs.
Well, remortgaging is not one, and that was not explored, but sell it certainly is.
Okay,
Yes.
sell it then.
Yes.
Let's assume sell it.
Yes.
And
That's the point.
the question is whether the consequences of not selling it can be visited upon the solicitors.
Absolutely.
I mean, an issue is, I think you framed it in terms of whether it was reasonable for the company to continue to hold the property.
Yes.
Whether it was only reasonable for them to sell it. I'm not sure Mr. Stewart would accept that that was a relevant question at all.
Well, he not unfairly, correctly adverts to the fact that reasonableness can be inappropriate when one's talking about speculation, because something can be commercially reasonable, but nevertheless break the chain of causation. We accept that, and that's the nature of speculation. If something becomes a speculative commercial risk that's therefore outside the scope of what's for the defendant, then the decision to hold in a case where one has, say, a fungible good where it's obvious you're trading, the the decision to hold is a market decision that you're making, and that's not to be visited. And I completely agree with that. And whether one says it's unreasonable to hold or not, perhaps inappropriate. The question is whether it's
your
speculative.
choice. You have an option. You would go one way. Why should the defendant pay for your
Absolutely,
choice?
my lord. And I'll show you the decisions in due course. And the decisions we all have in mind are sale of goods, fungible goods cases where it's obvious that trade is what is in mind. Although even there are of course cases where what is in the contemplation of the parties is, for example, a string contract, because the defendant knows that. And in that case, the claimant is entitled to say, well, my losses are measured by my later on sale. It's not speculative of me to hold the goods or to claim losses on the on sale, because you knew that was what I was doing and that's my business. But normally with fungible goods, the available market is the end, because it's a breach of the chain of causation, and we accept that. And in that case, reasonable or unreasonable perhaps doesn't help. But where you've got a different sort of a business, the type of the business, we say, is very, very important, and the cases will show that. So we'll come to that, and you'll have to trust me or wait, or force me to do them now, which is the alternative. But, my lords, if we just finish this point, you'll see at main judgment, paragraph 81, which is at page 247. And my lord saying, if you or somebody tells me at what page the bundle divides it, I'll try to remind you whether we have to jump bundles, but it doesn't do it in mine.
So what was the page you just wanted to go to?
This one's 247, so I suspect we're still in bundle 1, but...
Yeah, about 350, I think.
Okay, thank you.
Certainly in mine, anyway.
I put it in a separate folder, it was just easier.
Yeah, perhaps I'll do that.
One folder.
My lords, paragraph 81 just summarises the engagement. So this is the engagement of the solicitors. Mr. King is of Stevens and Bolton and was the core relationship partner. And the engagement back when it happened in 2014 was in relation to this development. They knew all about it, which explains how we get to what we get to in a moment. So then just turning to the holding as a long-term investment for revenue aspect of this business. That's not really challenged. We refer to that in paragraphs 27 and 8 of our skeleton, but just the primary documents to show you. If we just go in the main judgment at 647, so that will be in Justice Snowden's second bundle. Sorry, paragraph 647, page 466. So I'm right, but I was wrong about my notes. Thank you. 466. We see at paragraph 647 that in the period of 2016 to 2021, which I'll come on to, for which the lost rent was ultimately awarded, there was a credit given for some actual rent that was earned in the undeveloped or property during the delay period. The figure's not important or challenged, but it's just a reflection of the fact that the property was earning rent beforehand, as one would expect. It wasn't vacant. We have, if we take out the supplementary bundle...
That's the 249,000, is it?
For that period, yes.
It's just that sentence.
That's right.
Sorry,
I don't think it matters. It was mostly vacant. The evidence at trial was that this was in relation to a small part of it. But there were...
Absolutely. We accept it as a dilapidated property by that time.
Sorry, the only point I'm making is a lot of the property was vacant, but it probably doesn't matter.
My lord, if we go to the supplementary bundle at 3, this is an extract of the fourth witness statement of Mr. Prashant Patel.
Sorry, it's just exploded.
Tab 3, my lord.
Yeah, it's I know the tab, it's just my file has exploded.
Oh. Sorry about that.
No, that's overfilled.
Overarching the levers. My lord, it's page S. Mine's got an S, I don't know why. S19, supplementary 19. And if we go over the page to 20, we'll see that at 184, and this evidence was essentially accepted in the judgment. At 184, Mr. Patel says, Suresh and I intended to retain as an investment with an income stream. The only exception is the affordable housing element, which is required to be sold, and was in fact sold, because of the nature of the planning commission, etc.
So what would you say that was? I mean, it'd be more useful if you showed us where the judge accepted that.
Well, yes, my lord, it's at the main judgment to page 299. My lord, if your lever arches have died, Mr. Stewart says they've.
Well, I've got an electronic version as well, so I may start using that.
We've got a spare hard copy supplemental if that is.
Thanks again.
Sorry.
So 299 of the core bundle 1. And if you look at page 219, sorry, paragraph 219, at the top of 299, says it was, and we'll come back to where he takes it up in the reserved matters judgment. Says it was his evidence that he intended to retain property as an investment. He's missed out the words with an income, but this is a summary of his evidence. We've seen what his evidence was. With the exception of affordable housing. And then if we go to the reserve matters judgment, which is going to be in the second bundle, or bundle, tab 19, page 547. This is the 2022 judgment. Firstly, we have paragraph 13, which, if you read the quotation, it records the evidence in the last two sentences of that quotation that Barrowfen intends to use the profits generated to pay a dividend from retained earnings every year. So this is an annual dividend. This is not a one-off sale dividend. It's intended to pay up to the family trusts an annual dividend. And then in the same judgment at paragraph 25, which is over at paragraph 5, page 553, we have another quotation, and if we look at the 5th to 6th lines, we can see that the intention to start to earn the rent, and then at paragraph 71, Lords, which is over on page 578, we have in the third line that he accepts the evidence of Prashant, intends to hold as a long-term investment.
Sorry. 578.
578, paragraph 71. Just read first 3 and a bit lines.
Sorry, that's accepting the valuation methodology.
that valuation is appropriate if Prashant intended to hold it as a long-term investment. I accept his evidence on this point, i.e. that he did intend to hold it, and you'll see that again at page 581, paragraph 78.3. And then at 78.3, which we'll come back to, the last sentence records the decision to hold investment for the foreseeable future, but then he says that's not a consequence of any breach. And my lord, you'll see from the skeleton, Mr. Stewart doesn't dispute the finding that there was intention to hold. The question is the one my Lord Justice Snowden mentioned, which is whether it's speculative and can be visited.
These are the finance costs that we're talking about, though.
Well, I'm talking about the decision to hold, but yes, this is where we have the reasoning on the finance costs, 78.
He says any finance costs which Barrowfen has incurred or will incur after completion over the life of the investment don't form part of the single continuous transaction. At the moment, my understanding is that you say correct me if I'm wrong, I've got this very simplistic.
Yeah.
The capital value of this property is derived from the income stream which it will generate over a period of time, capitalised back to a capital value.
Yes.
You say that should be diminished by the fact that over the same period the company should be or will be paying finance costs at a certain level.
Exactly.
As I understand it, the finance costs would obviously not continue to be paid if the loans which generate the costs were repaid out of the proceeds of a sale.
Correct.
And that's the point the judge is, that is the point, and that is the judge the point is making here, that the decision to maintain the property, notwithstanding that there are finance costs which the company continues to have to pay, is one which is for the company to...
Absolutely, my lord. My lord's ahead of me. So all I was trying to establish now is that it's not disputed there was an intention to hold and to take income. And the later question is, we wouldn't be here if the judge had agreed with us on this legal point, whether there's nevertheless a break in the chain of causation at that point, which is exactly what the judge finds here against me, and that's what I'm appealing, 78.3. Yeah. So my lord is right about that. I'm not saying the judge actually was with us on that legal point. Of course he wasn't. That's the appeal. But
I just wonder whether it really is dependent on how you decide to describe it. Another way of describing it might be that what they want is to generate an income for the family trust because they want the family to live on it. They think that the best way for the future of doing that would be to hold this. And therefore they're holding it because that's their judgment as to how to get the money for the trust. But it's not a separate disembodied... This is a property which the family wish to cling to. It's a property which they want to use to generate an income, and they think that's a good, desirable thing to do. So I don't know why you attach such heavy importance to the intention to hold it.
My lord will see in the cases, it depends how one characterises the business.
Yes.
If I'm in the business of making widgets and something goes wrong, I could sell that business. Is it speculative of me not to sell the business?
Well, if you harvest plasticine and you're doing a product and you need a factory in which to do the product, you've got to have a factory. But if you're a company that's trying to get an income stream for a family, and the way in which you decide to do it is by buying and developing property and getting a rent, it's not quite the same, is it? Or is
my lord's right. If I was a company called Berkeley Homes or whatever they are, then my lord would probably be right. But this is not a company that decides to buy land and develop it. The land is the company. They were formed in the 80s, and it's only one property in Tooting. That's all this company does. And this company held it, took some income, realised the income could be improved, and developed it. So that's why I characterise it as not as a development company that flips properties. There is no other property there ever was.
But my lord is and in fact I've lost the reference, and perhaps you can just provide it to me because I don't think I jotted it down. Where's the reference to the desire to apply the profits, retained profits, to pay dividends?
That was at Reserve Matters 13, paragraph 13, page 547. So the document you're in.
I think my Lord's point is to you, and unless I'm sure he can say it for himself, but so you say 547, C547?
Yes, paragraph 13, and then the quotation's over the page. And it was towards the end of that quotation, my Lord will remember, we just went to that. And the intention was to use the profits generated from the tooting property to pay an annual dividend. That was the point I was making.
And the point has been made, if that is really the point of the company, which is simply to generate profits to pay dividends to family trusts, it can do so, it can generate such income in any number of ways.
The intention is to generate money from the trust, doing it by way of a commercial decision that the best way is to get a return from this property is a second order thing, is what I'm putting to you in.
Well, my Lord is putting that, but that's not what the quotation says. It says to generate it from the tooting property, which is all this business has ever held. Harvest Plasticine may be able to make different things, but that's not what it does. It makes the widgets that it makes, and it could go into other businesses to make profits. And obviously it's a circular argument to say, well, Harvest Plasticine has to make widgets, and therefore it needs a factory. Well, Harvest Plasticine is a business that makes money, and there are other ways to make money. Should you sell your whole business at every point that you can? Of course not. The question is whether this is closer to the fungible goods instantly trade. Of course, one must expect you to sell it, because otherwise you're taking a risk, or whether it's a long-term business that is expected to make income. And what we say is the judge's own findings, and I'm going to move on to this, in the award made, show the judge didn't see it the way it appears he then saw it from the finding he made. So there's an internal inconsistency. I'm going to show you that now.
Just before you move
Yes.
on, so I understand the wider context. Is this the only company that the family trusts own?
I have no idea. I don't think so.
So the trusts might actually have a number of properties and be doing all sorts of things.
Possibly, yes. But the claimant is Barrowfen, the company, and that's... You can't...
But it isn't unusual to find structures where you have a company per property, when actually
Yes.
the overall picture is rather different.
Correct, my lord, but each company is its SPV, and what's that SP? The SP special purpose here is the tooting property. It's never had anything else as far as I know.
So would it be a breach of fiduciary duty for the directors to insist on holding this property if a more advantageous property came along?
Well, no. Of course not. I mean, it depends on the commercial decision, of course, but they have to make a commercial decision. But is it a breach of fiduciary duty for Harvest Plasticine to decide to keep making widgets? Depends on the market. I don't think that tells us anything, my lord. One's always free to move. Google can decide that the search business is not good enough and we're going to have to move into AI, or it can decide not to, and those are commercial decisions.
So the company can claim damages on the basis of its intention to hold for long term and resist the requirement to reduce the damages by the amount of the financing costs, and pocket them. But the next day, the directors could actually decide, actually, it would be better if we now sell the property.
Yes, they could, and that might, in fact, increase their losses if they decide to sell it for other reasons, and that couldn't be visited on the defendants.
Explain that. I mean, we got to a position where we're
Yeah.
told the company has a certain capital value,
Yes.
meaning presumably it can be sold in the market for that value.
Yeah.
So why would selling it produce all these other losses?
Well, what I'm saying is the decision to sell your business rather than continue your business may be commercially sensible. Maybe the bottom's fallen out of the widget market. But that must be a break in the chain of causation, because it's not what anyone contemplated, and between these parties it's not the business, you're moving business. We'll see that in the new flamenco. That's
Well, I
essentially...
think that's the problem. I think it's how you define the business.
Yes.
Is the business generating income from property?
Yes.
Or is the business owning 1, 2, 3 tooting.
Well, let me show you, my lord, because what one needs to remember is the award here of damages which the defendants seek a credit against is an award for the delay period 2016 to 2021. So the counterfactual, the non-breach position is that the development would have completed in 2016, which is 5 years earlier than it did, or 2018. There's two branches, but let's forget the loss of chance for now. Would have completed in 2016, but not been sold. It would have earned rent, less finance. That is the award.
I mean, the position is you lost rent but gained a more valuable asset.
Well, let's try to... I'm going to focus just for now on the non-breach position. That's right, my lord, in a sense. But I'm going to focus on the non-breach position. So what we have is that...
There's in the non-breach position, there's an 8% chance you actually would have got the... you'd have done this actual development. Anyway.
Yes. There's no loss for that 8%, we
Right.
say, but that comes up tomorrow.
Yeah, well,
Yeah.
okay. But this development, which you have done because of the breaches, as to 92%,
Yes.
is one that's more valuable because you can charge a higher rental for the lets. But that comes with an increased finance cost. And that's the equation, and it's a simple property question.
It was more valuable on these experts' evidence and findings in 2021. Well, will it be more valuable later? I don't know. And we'll come back to problems with that as well. But it's important not to... There are a number of issues that I rely on, and you'll see there was no comparison between the values in 2021. But that's another point. I don't want to set too many hairs running. My lord is right if you take a 21 valuation, and we'll come to that. But
If I understand you correctly, you're saying the implication must be that because you're measuring the loss by reference to a period when rents would be payable, therefore the natural implication is you've got to treat it as a business that would be long-term rent receiving, because that's where we began this discussion. But does that work?
Well, let me explain it to you, my lord. You're right, but that's my point. So if we just see what was awarded, if we look at the core bundle and the main judgment, so it'll be second bundle if you're in two bundles, page 637, sorry, page 562, paragraph, no, it must be the second judgment. So it's tab 19, page 562. I've got my pages wrong. 1 second. Right, I must have done. I think it must be 462. Sorry. So 462 in the main judgment. That's my typo. We see at paragraph 637. That there's an award of lost rent, which is quantified, the monthly rent, and there's various evaluations from there. So that paragraph onwards, which culminates in 645 to 6 at page 466, so here you have that, and if you read 645 to 6, you see if it had happened without delay, so this is called the amended original scheme. finished in 2016. The net monthly income would have been this. And then if you also look, the second sentence of 645, that 34,950 had to be deducted from the rental income for financing costs. So all the claimant claimed, you delayed the completion of the development by 5 years. All we're claiming is the lost rent. We're not going to get into whether the ultimate development was better or worse. And I'm not saying one can't get into that. Of course one can. But it was a simpler claim at that time until the defendants brought that issue in late. We just claimed the lost rental income less the saved finance costs. Because had the development completed, there would have been post-completion finance costs, which were 34,950 per month plus interest. And you can see a little bit more about that in the supplemental bundle at tab 2. Tab 2 is an RFI response. So the defendants RFI'd the claimants on their heads of loss, and then if you look at page 8, you'll see at the bottom of the most of that page 8, there's the answer that let us explain what our rental income losses are. There's these rental incomes that we would have had. These are actually net rental incomes because they include deductions for costs of maintaining the properties and whatnot. And then at the bottom you have a reference to the fact that under the RBS financing proposal, post-completion, there would have been payments of 3% per annum, which is 419,400. And if you divide that by 12, you get the figure that was in the judgment. So the award here, I could show you the funding proposal. It's referred to in the judgment, but I don't think you need to know that. The point, it's not disputed, because I think it happened in both developments. You have a loan that funds your construction, and then as soon as you complete it, flips into an investment loan where the terms are slightly different because you have a completed development as security. So it's the same loan, but I think the terms change. But here we're clearly talking about financing costs post-completion 2016 to 2021. And this wasn't raised by the defendants, it was the claimants volunteering that our lost rental profits from 2016 to 2021 were our lost rents, but we did save on financing because that was what our business would have been. Post-completion, taking rent, but paying finance and security and maintenance and whatever. That's our net profit, and ultimately those figures were found, and that was the award that was made, and that makes up what is, apart from some costs, turns into 4 million, but was reduced by this credit. And there's no magic about financing costs, they're just a cost. They could have been cleaning costs and any cost. They're part of the business. Servicing debt is part of a business's accounts. It's what happens here. And the assumption there is that Barrowfen keeps its 14 million RBS debt. I think it's 13.98 million. That's what it's keeping, and it's paying it. That was the claim made. So having not sold the judgment, sold the land and the development. Now, we're in the non-breach position, but what didn't happen is no one, the defendants nor the court, took objection to that, saying, well, Barrowfen would have sold it, which is not disputed, isn't the case, or should have sold it, or in any case it's lost.
Sorry, I've lost you.
Yes, my lord.
You're dealing here with what the judge assesses as the loss of rental income during the period of delay,
Mhm.
whilst the property is being rebuilt under the original scheme.
Well, it turns out that the delay ended when it ended, but in this non-breach world, the development finished in 2016. So it's just post 2016, but the reason it stops at 2021 is because in the real world, the development completed in 21. So that was the delay. I think my lord's right, but remember, this award is just about the non-breach position. Nothing would have gone wrong. We would have developed it earlier, and these are the incomes we would have made, and these are costs we would have made. And what no one said is that's too remote. It's not in the contemplation of the parties that you would draw income. You should be selling. It's totally unreasonable for you to just keep these finance costs of 14 million. Indeed, by it not being too remote, which is implicit, what that means, we know that, is that it's within the implied allocation of the parties' responsibilities, because that's what remoteness is, that the business would draw income and pay finance and not sell. And that's why that award stood, and that claim was unchallenged as a matter of principle, and that was the business for which loss was awarded.
I'm afraid I'm confused.
Yes, my lord.
What we're concerned with, for the purposes of your appeal, is the question of the value of the completed property. In a different world, you would have had a different completed property.
Yes, my lord.
But that's not the basis of your claim. Your basis of your claim is lost rent. Now, how can remoteness come into the financing costs? I mean, if you had the defendant said, well, the financing costs are too remote, you'd have got all your lost rent without regard to financing costs? Or how would it have worked?
Well, so what would have happened is the defendant say, I know we've been your solicitors for years, but your business in deciding to hold a property after its development is your own. And that's your commercial risk. As far as we're concerned, once you've completed the development, you've got a capital value. So your losses have to be restricted to the losses within the contemplation of the parties, which are the capital value of your property in 2016 on completion. If you decide to keep paying finance and earning rent, well, that's your decision to stay in the market. But that's not the business that we contemplate. But obviously,
so the question of damages would have been exclusively by reference to the capital value you would have achieved in 2016 or whatever.
Yes.
And that wasn't your claim.
That wasn't our claim, but if it was too remote, then our claim would have had to be recharacterised as that.
I mean, your point, and sorry if I'm being slow.
Yes.
But you're simply pointing out, are you, that nobody suggested when this computation at paragraph 645 to 647 was being done that the company should, in fact, have sold the property on completion. Is that the point?
Well,
I mean,
no one suggests. It's in the same judgment as the judgment that says the credit should be applied. So it's not a.
Sorry, could you just?
Yes.
I'm trying to.
My lord is right.
What's the point?
It's not that no one said it,
you're trying
my lord. It's that by awarding those damages, the court is accepting that the business of renting and paying finance, i.e. keeping your land that you've held for 30 years for longer, in this case it was 5 years longer, is within the party's contemplation.
So I'm trying to understand.
Yes, my lord.
Do you say that consistently with Mr. Stewart's case now, you shouldn't have had any award for lost rent?
Yes.
You
We
simply
should have
done a
had.
capital.
We should have had some sort of capital valuation at 2016. But the point is that
And then you'd have.
we'd have had loss
Had some
interest.
compensation
We'd have had
for-
interest for loss of use of money.
Yes, I see.
But it's not that the judge got it wrong that way. It's that no one challenges this part of our award, and therefore it implicitly follows that you have to be consistent on the breach side of the equation and say, well, we've got an income-generating business. It's not too remote. The parties contemplate it. Just like my string contract case, the reason why I can defend on both sides of the equation is that you understood that I was going to be selling to a particular person, or you knew that my mill shaft was going to be used for this, or you didn't know. So once you know what a business is going to be, well, that's the business. You have impliedly assumed responsibility to compensate the consequences of breach for, and therefore it can't be said, I say, in those cases where you've got that within your contemplation, you can't later say, well, it's speculative to carry on your business.
Is this really a forensic point?
No.
I mean, does the fact that you obtained damages on this basis preclude Mr. Stewart from arguing his point? If it doesn't, then this is a forensic point.
Well, it's a forensic point in that it shows the judge's reasoning was wrong because he didn't deal with the point. But it's consistent.
Now, what does that mean? Sorry. It shows
Well,
the judge's reasoning was wrong because he didn't deal with the point?
Well,
his reasoning that you are now challenging was wrong because he didn't deal with which point?
Well, it's the forensic aspect is just why was this not why did the judge not see the inconsistency? But I make a broader point, as I just made, which is I say Mr. Stewart's not entitled because once that business is in the contemplation of the parties, so what the remoteness test does is it says, what business do you understand for the purpose of damages the other party's running? And if you can say something's too remote, you're saying, well, that's not, you may have a private, very valuable deal to do laundry and dyeing for somebody, but that's, I didn't know about the Ministry of Defence contract. So that, to that extent, the business is not that business. But I know you're in the laundry and dyeing business, and therefore if what I do causes problems with your laundering and dyeing business, you can claim laundering and dyeing losses rather than just claiming some sort of capital value. Well, again, we'll come to the cases, but it's the same with Harberts, it's the same with Parsons Machines for the railway. I'm in the railway business, and so if you supply a defective machine, let's look at how that affects the profits of my railway business. If you can say, well, I didn't know you were in the railway business, you just said you wanted a machine, well, then you're probably stuck with capital value because nobody knows you're going to use it for a profit-making purpose.
I hear you to be saying two things, actually, but I may be wrong. I hear you to be saying that I'm working out what the business is by reference to the basis upon which loss was calculated, and that shows it's the rental business, long-term holding of property for rental business. I'm not sure the latter follows from the former, but that's one thing I understand you to be saying. The other thing I seem to be understanding you to say, and you're telling me I'm wrong, is it's in some way inconsistent or inappropriate to switch. You value the loss on the basis of rent. How thereafter can you switch to valuation of loss by reference to notional capital values of the property? You should either have done that when working out what they suffered as a result of the delay, or you shouldn't. And what you can't do is mix and match. Start off and say, right, there's delay, they get the rent, but in that case you work on the basis it'll be rent only, and you can't switch to capital value. That seems to me to be the two things you're saying, or have I misunderstood?
My lord understands me. I mean, what I don't like about that characterisation only is that my lord says, what's the valuation approach? And it's not useful, I think, for us to talk about valuation approaches. The judge did that as well a little bit. But the question is the chain of causation broken? And we have to apply a legal principle. And whether it helps me or hurts me, that's what we have to do. So I say the inconsistency is finding that a particular characterisation of the business is within the party's contemplation and their implied assumption of risk, but then saying that continuing that business is a speculation that breaks the chain of causation. You could have that in particular circumstances. You could have a bespoke situation where it's not because you've sold the business that it's a break in the chain, it's because you've sold the business in a particular climate where things have changed dramatically, you've lost funding, to carry on is hopeless. I'm not saying there can't be individual circumstances, but the judge here based it solely on the fact that you could sell, not on a particular decision made by Mr. Prashant Patel, and there was no cross-examination, partly because of the way the issue arose, and no expert evidence saying, well, why is it better to hold or not hold? Let's talk about that. Should you have sold? What else could you have done with the money? Or is, in fact, this the best thing you can do to deploy your money to get your income stream? This wasn't explored, and Mr. Stewart can tell me I'm wrong later and show you where experts talk about comparable investments for this purpose and that it's therefore an open business question and that no one would hold in these circumstances. But this wasn't the way the issue arose, because the judge puts it solely on could, and so does Mr. Stewart. Because you could sell, that's enough. And he has to, because we'll see the reasoning's very thin, because the point arose in a diffuse way. And the witness statements were before the point arose, and then there were later witness statements, but just about finance afterwards. But there was no witness statements about should you have sold, because the point was in between those periods. So that's what we say. We say it's just inconsistent and wrong. And I'll come on to show you a further respect in which it's wrong, which perhaps runs at the point again. My lord, and it's topic 4 on my list, which is the breach position, what actually happened. So rather than the 2016 to 2021 this is, I've told you already the non-breach position, it was found that we would have earned rent but paid finance, and I've made my point on that. In the breach position, of course, in that period there was no rental income because the development had been delayed. So there were the costs of getting the whole revised development going, which are sort of legal and administrative costs, and those were awarded. But there was no claim by Barrowfen for the increased construction costs or increased finance costs, because it wasn't trying to bring into account a general comparison between the two developments. Now, you might say, well, that's simplistic. And it is, but it's the way the claim was formulated to hopefully bring about a much more limited and cheap trial as it would have been. But once one brings into account the credit, and I accept that one is entitled, if you're following through the measure of damages, which is breach position versus non-breach, to say, well, let's not just look at that, let's look at the developments that happened. But if one does that, we'll talk in a moment about what one has to do. But just to show you, if we go to reserve matters judgment, that's at tab 19, so that will be the second core bundle if you have a split. If we just go to paragraphs 54 to 5, which are at page 5, 6, 8. So just to, and I think my lords already have this point, but the way the revised development came about, because after administration, when the company came out, Waitrose had left the development, it had to be revised, it had to be bigger, the costs had increased by, I think, 10 million. And so as it's summarised there, you've got additional borrowing, and as it said in 55, the revised development is slightly less profitable than the original development scheme if it had been implemented in 2016, which it would have, but for the breach in 92% of the probability tree. And it's slightly less profitable because when you take into account the finance costs, although it still makes money, it makes less money. And
It makes more money, but it makes less as a percentage.
well, it makes less money when you take into account the finance costs, which is why ultimately, if you take into account the finance costs, the credit becomes negative of 959. But we'll come back to that. But my lord, just to remind you, there was an argument by the claimants at trial that the whole development, the revised development, was too much of a creative process to be within the chain of causation, and there's a break of chain of causation. You shouldn't take the revised development into account at all. And the judge found against Barrowfen on that point. And you can see that at paragraph 66 and 68 of this judgment, and that's not challenged here.
Sorry, that was paragraph
66 and 68.
Yeah.
Well, 66 explains that what happened in the revised scheme was it was a mitigation. It was an attempt to do the best with the situation that you had, and it therefore follows, as night follows day, that it's within the chain of causation because it's a reasonable mitigation. And then at 68...
What about the last sentence of 66, which seems to be the basis of the judgment? It made a profit on its investment. It made a profit which exceeded the profit it would have made if these breaches of duty hadn't prevented it from developing earlier. And by doing so, it avoided some of the losses which it suffered as a consequence. So you said you can't really do that because you're switching from the rental measurement of loss to a capital loss. But he seems to be saying, look, this is a thing that's meant to generate property for a trust. Because of all the delay, it's making a bit less money by way of rent, but swings and roundabouts, the thing that's generating the income is worth more.
Well, I'll show, yes,
And
it
you don't
depends
agree
what
with
one
that?
means by made a profit. And he then goes on to accept, I mean, we saw he says it's a notional profit in his permission to appeal, and he does have some reasoning on why that profit's contingent upon assuming a sale, because
It's
otherwise...
only notional because it hasn't been realised yet. But the point is that were it to be realised, if you stand back and say this is to generate income, for 5 years you couldn't get any income because of the delays,
Yeah.
because of the breaches. But at the end of the day, when it was finally developed, yes, you'd lost some money, but on the other hand, it's worth a bit more as a thing. And what's wrong with that reasoning at the moment is what I'm struggling with.
Well,
Is
what's
it just
wrong-
what you've already said, that the business was long-term income, and that's it?
I've already said that if you want to know whether it made a profit which exceeded the profit it would have made, you have to look at the ongoing business
Not
post
the,
21 and compare it.
and that's
It could have been more profitable. So what could have happened is that the balance between increased rent but increased finance costs was the other way, such that the new development is more profitable going forward. And then when the defendant says, I want you to bring into account the RDS, and we said, well, the whole RDS needs to be disregarded, and we lose on that because it is a reasonable mitigation, then our damages would be reduced, because if you look at the ongoing profits less the ongoing costs, we're making more net than we were, and therefore gradually over time our previous losses eroded and we end up getting nothing if that were the numbers. So you can work out, it could make more profit, but you have to look at the business on both sides the same. So that's what we say. It's an accident of the numbers that it happens to have gone the way it's gone. But when you look at did it made a profit that exceeded, you have to look at profit of the business.
Well, you're saying you can only look or measure loss by reference to the rental, not by reference to the capital value of the property.
Yes, and if we sold the business and said, well, let's say the business makes more rent and costs a bit more finance, the revised scheme, but still ultimately is net more profitable. And we say, oh, well, that doesn't matter because we decided to sell it, and actually that didn't really produce as much capital as you might think, so we still have a loss. The defendants could say, well, you decided to sell your business, but that's your own speculation. This was a more profitable business. Look at the rents you could have made. You've done a new flamenco. You've just sold out a business that's income generating, and you've made your own decision. I'm going to disregard your sale.
But are you not mixing up different things? I mean, the judge is saying there's mitigation in fact, as I understand it.
By doing the RDS, not by selling. Yes.
By doing the RDS,
Yes.
he says there's mitigation in fact, and he values the mitigation in fact in a particular way that you take issue with.
Yes.
If you had done something unreasonable by selling when it would have been better not to sell, then that would be failure to mitigate.
Well, no. I'm saying we complete the RDS. That's what he's found is mitigation. We complete it through to the date of completion. So that was all of his finding, that doing the RDS was in connection. I mean, on his finding, if we'd sold at 2021, that wouldn't have been breaking any chain.
No, quite.
Yeah. So I'm saying it...
But you say on different facts,
yes,
the defendants could have complained that
we
you
could
had
have been on the other side of
you
the
could have
argument.
taken the wrong choice. You could have done something unreasonable. But if you're in the territory of doing something unreasonable, then you're into the territory of a different kind of mitigation point, which is failure to do what's reasonable.
Well, it doesn't have to be unreasonable. It's only unreasonable in the sense of speculation, because it could make good money, and it could be a perfectly sensible thing to do. You might think, I'm concerned about the global buffeting of the LIBOR rates, and for my own reasons, it's better for me not to have money in the UK, and so I sell.
But then you might be all right in the sense that if you do something in pursuance of reasonable mitigation, which turns out badly, then the claimant wins.
Well, my lord, what we say is, yes-ish. You have to look. If you're going to go into a bespoke mitigate or failure to mitigate, you have to look at the actual decision. You have to have evidence about the decision. What were the reasons? Are they your own personal reasons, in which case they can't be taken into account anyway? The fact that you prefer not to have UK money, maybe neither here nor there. You're a widget-making business and I can expect you to continue widgets. Or maybe I knew that because I've also advised you on Forex transactions and therefore it's all within my contemplation. You've got to analyse the decision made, cross-examine about it, probably have experts, and decide, as sometimes happens in the decisions, as in Herman and Withers, my lord decided, that actually there was a better thing to do and it was obviously better and everyone would have done it. When you're in the situation of buying and selling, that's going to be much more difficult. And what we'll get from the new flamenco is just that, well, it could be perfectly sensible. In that case, it made lots of money to sell the ship early. It made lots of money. So no one could say, well, that's a foolish decision. It's totally reasonable. In fact, you might even say everyone would have done it. But nevertheless, it's a speculation because you've changed your business. It's a breach of a charter, that case, which we'll come to. So,
but all we're concerned with here really
yes.
is mitigation in fact. And the question is, how do you value the mitigation in fact?
Well, so if you're talking about fact, then it's pretty clear I win because they held the business. So having done the RDS, they then drew rent but paid finance. That's what we're doing. So in fact, that is the position we have achieved. And to what extent was that a mitigation? Well, we look at the numbers and it turns out that we're making good money but slightly less than we would have made on the AOS once you allow for finance. That's mitigation in fact. That's what we did. If you want to depart from that, you have to say that something we did or didn't do here breaks the chain of causation. And we say that selling your business does that. It helps the defendants in this case to say, because of the way the numbers fall, to say you should have sold. But in another case, it might have, i.e. that not selling is a speculation because you've got a capital value. But in another case, it might have gone against them. And either way, crystallite, cashing your chips in when your business is earning rent, you've just claimed the loss of rent and we contemplate you're going to earn rent and pay finance, is, we say, that's the speculation, selling your business. And it might be reasonable. But that would break the chain of causation, had it happened. And certainly it follows, as night follows day, that not doing it can't be a break in the chain because all you're doing is carrying on your business. So that's why we go back to, where is the case where someone sells their whole, is deemed to sell their whole business, not a piece of property. This is a development across Tooting property. Let's imagine this. We've got Tooting property, but let's assume, contrary to the facts, that half of it was actually not dilapidated. There was a good supermarket and some nice flats, and there was nothing to be done to them. But there was also a quarter, half of it, let's say half. Half of it is some dilapidated warehousey buildings that are generating no income, and the decision is sensibly taken. And they're all intermingled, but to improve the income, we're going to develop the half of the properties. We're going to leave the car park, and we're going to leave the supermarket, we're going to leave the flats, we're going to develop some offices. And you do that, and it was delayed. And you get to the end of it. Do you deem that the claimant should have sold all of their land, including the car park, the warehouse, the flats, to which no work was done, because they've now completed a development on the other half? Could be half, could be 10%. And we say, obviously not. Why not? Well, because you're just keeping up your business. And in fact, you've held one bit for 30 years making rent. Why would you be expected to sell out the whole thing? What's the difference just because you were developing all of the buildings? There is no difference of law that's material. What you have is you've done a development, you've completed the development. You could sell. You can always sell anything. You could always sell your property. You could say, now I've developed half of it, I'm going to sell, or 10%, or one building, or a garage. I'm going to sell the whole Tooting property that I've held for 30 years because I've completed the repainting of the front of one building. You can sell it. You can always capitalise it. And could you say, well, it's speculative. You're just keeping going earning rent on that. And in fact, when I look at the numbers, it looks sensible to me to sell. You don't even get into that. Just because you're developing all of the buildings on the property, it's a piece of land. You can't sell the buildings on their own. So you can still got to sell the whole land. Just because you're developing all of the buildings, we say no difference. You can keep earning your income, and that's how you measure loss. And that's why in Harbert's plasticine, you don't say, well, instead of rebuilding a factory, sell the business. Because there's the rest of the business. But why would you sell it all? So the fact that one can sell something and capitalise it into a capital value at a particular time, and we'll come back to the timing, doesn't, where you have a business that is run for income, i.e. a business, doesn't break a chain, failing to take that capitalisation to exit your business, doesn't break a chain of causation, save in particular circumstances where it's all going wrong and someone's presented an opportunity, and sort of more bespoke Herman Withers type case. And indeed, to sell would break the chain of causation. See New Flamenco. Now, the way it was pleaded, just very briefly, if we just look, because we probably should do this, this is at Core Bundle tab 26, so that will be second bundle. This is the amended defence. And perhaps I should just show you the particulars. That if you look at tab 24, and if you look at page 672, you will see that at the foot of page 672, there's a claim for loss of rental income. But also that at one time, and it was added post-original and it was removed before expert evidence, at one time, so this is AA, at the top of page 673, the claimants did claim a lost developer's profit, but taking into account increased costs and increased financing costs and increased rental income. So a version of what we now say would be the coherent outcome if you were going to go down that road. But then that was removed before we got to experts. And then just to look at the amended defence of D2, so you're at tab 26 now. This is page 770. And this is the plea as to loss.
Through which page?
770.
Oh, yes, yes.
You have that?
Yep.
So it's under heading loss allegedly suffered, and if you'll see at 191.3a, that's the amendment that added in this issue. And they said, well, actually, the development led to an increased gross development value. They don't say increased developer's profit. There's no allowance even for construction costs. They just talk about gross development value, for which they must give credit. And they refer to figures in a report. And so it's not made any loss. Then they argue some causation things that are no longer live about whether it actually would have happened or not. And so that's what went in, and that's why the evidence, there's no mention there of breaking a chain or speculation or a deemed sale. And the expert reports aren't very clear whether they're talking about a market value for sale or not. it's all a bit opaque. They do give a gross development value, and I'll be showing you those values. But that's how it arose. They just say an increased gross development value.
But the judge deals with this and does take into account construction costs and comes to the increase in developers' profit, or which is what we're debating, isn't it?
Yes.
2.5 million.
Absolutely.
Right. Okay.
The point is only that there's no mention of sales, including in the expert reports, really, of sales or breaking chains or speculation, and the evidence never therefore went that way. There was no evidence, and it's not disputed that the burden would fall on the defendant to show a break in a chain of causation. Now, they say we showed it because of could. All we need is could. And they did show could, because of course you could sell. But they never went or therefore achieved anything anywhere further along the lines of, let's look at the circumstances you were in, what income you were trying to get, which is, of course, a burden on a defendant. Now, the figures that my Lord, or Justice Snowden just referred to, if we go to, it's probably time we deal with that. If we go to the main judgment, tab 18, it'll probably be in volume 2 for the split bundles. For page 471, so at 471, we have paragraph 664, and then if you just also see page 473, there's a similar table.
Well, isn't it more convenient to take it at C545?
No, in a moment, yes. That's where it has the single table, my lord, is it? Yes, but what that doesn't show is how you get there. So I just want to show you the underlying figures. But my lord's right, we will be going there.
So it's 664 and 671, is it?
It's 664 and 671. 664 is the revised development scheme, and you'll see how the profit is derived. It's a 12 million profit derived from a gross development value of 40 million, less construction costs of 27. And that includes a figure for historic financing costs. And then you see for the original development, it's a developer's profit of 10 million. So that's where the 2.5 million delta comes in, which becomes the key figure for the credit. There's a difference between the 12.6 and the 10.1, and the 10.1 is derived from a GDV of 27 less. It's called the developer's development cost here, but it's the same as construction cost, I think. 17 million. And we then have page let's check. Paragraph 672. So just at page 474. The judge, so this is in the original, the main judgment. The judge quantifies the credit as 2.5 million, and it's produced a developer's profit of 2.5 million more than the original development.
And just to be very clear, so that I'm clear, sorry.
Yes,
the amounts shown, for example, in the table at 664 for retail, community, hotel, residential, that go to make up the gross development GDV, gross development value?
Correct.
Those are based upon a capitalised income stream.
They appear to be net present values of the income stream, yes.
Yeah. That's not quite right for the residential. The residential on the revised development scheme consisted of a large number of flats, and they were valued on a capital basis. The evidence was that they were going to be rented out by the claimant. But in the revised development scheme, as opposed to the original one, you had a whole load of individual residential units, 1, 2 and 3 bedroom flats, which could have been sold individually.
that's helpful. The student accommodation, my lord will recall, had to be sold and was sold, and that was just done on a
The
capital
affordable
value.
housing accommodation.
Sorry,
surely
yeah,
if
the
you
community
afford-
social housing, yeah.
Yeah, social housing, not the student accommodation.
No, sorry,
Abandon
my
that
lord's
too.
right, yeah.
Yeah.
That's right.
Sure.
So, just one point to take before we go to the consolidated table. You'll see that the comparison here is between the revised development scheme, developer's profit, at March 21, and the amended scheme at September 16. We never had a figure for what the original scheme would have been worth in 21 after 5 years of rental income. Because the evidence was first put in by the defendant's valuer in a supplemental report, I think in February 21, and that wasn't a value that they took. And this is quite a serious point, because if one disregards the difference between the two developments, then there's nothing wrong with just awarding lost profits for 5 years, and that's a perfectly sensible thing and no one challenges that. But if you're deeming a sale of the revised development scheme in 2021, so that's what you're saying should have happened or is deemed to have happened in the actual world, you obviously have to compare that with what would have happened in the non-breach world, and that has to be either of you would have earned rent for 5 years to 2021 and then sold it, or you would have earned rent for 5 years to 2021 and then continue to earn rent forever, and we have to capitalise that income stream, but obviously paid finance for that period. What it can't be is you would have sold this in 2016. There's no world in the non-breach position where that would have happened that anyone has maintained, and it's inconsistent with the award of 5 years' rent. So all of the numbers are wrong. This is a point that we did. This is a point that we did take. It wasn't me, but we did take. It's in the supplemental bundle. I think this is an extract from the Barrowfen's opening. It's at tab 5, page 27. This was filed, I think, the day after the expert.
Give me the reference again. Sorry, I was making a note.
Page 27 of the supplemental bundle, tab 5, which was a file. So it's the written opening for the trial, filed the day after the first expert report of the defendants.
This is the opposition to the application amendment.
Yes, exactly. And then if you look at paragraph 3251, you'll see the points taken that you just can't do the credit on the evidence provided because you have to have the same date or a coherent view as to what's going on in 2021. Now,
Sorry, can I just
yes,
read it?
of course.
Yep.
So, nowhere in there's no answer to this ever given by the defendants, and the judge doesn't advert. So nowhere in the judgment is it said, and we have to assume that after the 5 years of rental, the claimants would have sold in 2021. Bearing in mind that we're in the non-breach position here, where we've already found that you would have drawn rent indefinitely from 2016 onwards. So probably the rational thing to do would be to value the rental income stream at 2021 less.
Sorry, who's found? Sorry, what? So you say we've already found that you would draw rent indefinitely?
Well,
Sorry,
there was an award of rental income from 2016 onwards. And it only stopped in 2021 because all of this valuation happens then. No, there's never been a suggestion that let's say the delay had been 10 years. The rental income would have been 10 years. It only stops in 21 because that's when the revised scheme catches up and completes. So it's never said that the original development scheme, if completed in 2016 and drawing rent, would have stopped drawing rent. But even if that were to be said, for some reason it would have been sold in 2021. And bearing in mind that in the non-breach world, you're not thinking about the revised scheme because there's not been a breach. Everything's fine. You've completed your development in 2016. You're earning rental income. Is it said that you would have sold in 2021? But even if it is said, you then need to value it at that date. What you can't do, and I'm not saying it would have been higher or lower. I just don't know. But what you can't do is say, well, I've got to credit the value on a deemed sale in 21 in the actual breach world, i.e. let's assume you'd sold once you'd completed the development. But I'm going to set that against a capital value in 2016, although I'm also awarding you rental income to 2021. It just doesn't make sense, as we say there. And so the credit is inherently flawed, and therefore the 2.5 million is vulnerable, because it makes no sense, because it's comparing apples and oranges, or, if you like. So it's incoherent. It's coherent if you just say, I'm going, not the award, but what would be coherent is to say, I'm just going to ignore the comparison because I don't have reliable figures on it, and I'm just going to award the lost rent, and as was originally claimed. And it's coherent to say, well, if I'm going to take into account the development, I've got to make a finding as to what would have happened in 2021. Presumably, you would have continued to earn rent, and I've got to have a valuation that discounts to 2021 the date of trial, future income stream less the finance costs, which may be any number, and I'm going to compare that with my deemed sale in 2021 in the actual world. It's just gone wrong. Because the credit came late, the evidence was formulated badly by the defendant, and so you've got a number that can't be relied upon.
Is this part of the grounds of appeal? I mean, as I understood it, your point of principle was you don't simply look at capital value or whatever in 2021, you take into account future financing costs. Is it part of the grounds of appeal to say, well, actually, the calculation was wrong anyway because there's a comparison between a 2021 value and a 2016 value?
Let me look at the grounds of appeal, but certainly, first of all, I'll take you to our skeleton. It's definitely in there, and I've got the reference on.
Well, it's just so that it helps. On this point, the judge, after the application for permission to appeal, granted two things. He granted permission for the claimant to put in a re-amended, I think, reply, and an expert report. The re-amended reply did not take this point, and the expert report did not deal with this point, and it was not dealt with afterwards in argument or submissions before the judge beyond the passage which your lordships have been shown in opposition to the application to re-amend. And if it helps, we say it's without the grounds of appeal, just so that you know what our position in relation to this is.
My junior's going to no doubt give me the references in a minute. I know we took it in our skeleton, and I'll look back at the grounds. I'll come back to that in a moment.
It's really a comparison point, actually.
Yes, ma'am.
Because the position that we've got to is the thing should have been built in 2016. If all these shenanigans hadn't happened with the trust register and the letter register, if all of that hadn't happened and it hadn't gone into administration, it would have been completed in 2016. It wasn't, it was completed in 2021. Where are you now? You would have had 5 years rent and therefore you get the loss of rent. What else have you got? You've actually got something that has a gross value as shown in 2021.
49.
And the question then is, I think back to the same thing you've been saying all along, is this a business to generate income for a trust, and they could have realised that by selling it? Or is this a business holding a property, and that's what it is, it's a business holding a property and everything else follows from that. So I'm not sure the comparison helps us, because what we're asking, isn't it, is when you get to March 21 and the thing is finally built,
Yeah.
how long did it take so that you lost the rent, and what's it worth now? So why is the comparison so critical? I understand how critical it would be were you to adopt what is the notional value difference, but I'm not sure it's critical to the way the judge put it. And if he's made a mistake, I think it's the mistake that you said this morning rather than the
No, he made two.
comparison.
He's made
You say
two
he made
mistakes.
two.
But I'm just trying to show you that the credit doesn't work even if he's right to deem a sale. We don't have available the numbers to do that. The reason for that is the 2.5 million number, which is all that I think my learned friend talks about in his skeleton. The 2.5 million number is not a cash sum. It's the differential between those two
schemes.
tables.
Yeah.
It's the 40 less the 27 versus the 27 less the 17.
Versus the
So
10.
why is it 2.5, not more, not less? Because you have to... My lord is right that the credit is actually the 13. The 40 that you would have sold for in 2021, less the 27 finance, leaves you 13. That's the credit, not 2.5. But you've got to then look at the non-breach position. What do I have? Now I'm taking into account the whole future. What do I do? And you either take into account a capital value at a date, or capitalised rental income less capitalised finance, or a mixture. But what you can't do is take into account an inconsistent mixture, which assumes rental value for 2016 to 2021 and capital value at 2016. You can't do that. So the 2.5 comes from deducting from the 12 the 10.5, but the 10.5 is a valuation at 2016, so it just doesn't work.
And I think I understand your point on date, but can I retreat a little bit
Yes.
and demonstrate my ignorance of this, perhaps, and don't tell me if I'm wrong. We're looking at these two tables. At the moment, I don't actually understand why we can't look at the one I asked to look
Well,
at.
I was about to go to that one.
But anyway,
We turn it
okay,
up.
it's fine. Let's look at these two because they're the same figures.
Yeah.
As I understand it, in order to calculate developer's profit, what the valuer does is say either what would somebody pay to buy this asset with an income stream, or the capital values of the individual flats if they are in fact sold as flats. In other words, there may be a mix and match between rental and capital, but this figure for gross development value is a figure which is arrived at by a valuer saying, what would somebody pay for this finished development?
Essentially,
Yes?
it is...
Because it's saying, what would somebody, what if this property was sold by the developer on completion, what would somebody pay for it, either as a property which generates an income stream, or because they are actually individual pieces of property which are sold. Right?
Yeah.
So this value, this gross development value, is a notional sale as at the date at which it's done. Less you then take off the development costs to reach something which is described as a developer's profit. So the whole ethos of the valuation is a notional sale, isn't it? It's asking what would somebody pay for this income generating property or these capital properties. That's how the values are approached. We haven't looked at it, but that's the underlying basis of these values, correct?
The answer is broadly yes. There are different bases of valuations, and there's an investment valuation which assumes a value of the thing as an investment without a sale, and therefore has to look at ongoing values. But the essence of it is that for most purposes, a net present value of an income stream is valued by reference to the market, because there's not really another way to do it.
Right. So in my simple little world, we've got a valuation of the original development scheme if completed in September 2016, and you basically say what could the developer have sold notionally the completed original development for at that date.
Yeah.
Take away the costs which it has incurred to get there, and that's its profit. Yes. And then you do the same exercise to the revised development if it had been completed in March 2021. So you say, well, what would that have been able to be sold for notionally in 2021? Take away the construction cost, you get a profit. So you arrive at a notional sale for the purpose of the valuation at two different points in time, and you have two differences. The first is you have a different profit on the two different developments, which is a delta, as you called it, the 2.5 million approx. But then you have something else, which is the fact that you would have completed one development before the other. And you would have completed, and both of them would have in fact been completed, I think, before the original development, would have been completed at an earlier stage, and therefore you have to compensate for the difference in time between the two completions, which is the rental. Those are the moving parts for the valuation.
Yes.
So, in a sense, in any valuation exercise, you are notionally selling the property, aren't you?
The judge agrees with you, my lord. If you look at our skeleton, I think it's the last page of our skeleton. There's an appendix, and we quote the judge. And I think this helps, my lord. I think this is your point to an extent.
Yeah, I'm not sure I'm making a point instantly. I'm just trying to get my
head
okay. Around the point.
Well, I'll show you how far I agree with you.
But believe me, I could, when there's a point, it'll be obvious I'm making one.
Okay.
This is just I'm trying to understand, right? This is
my lord, understood. Understood. Well, how far I agree with you. If you look at page 24 of our skeleton, which is the last page of our appendix that goes through some numbers, you have...
Hang on, you need to give me a chance to find
your
skeleton. Skeleton will be
tab 3, bundle 1, isn't it?
Yeah.
Oh, sorry, I've just got this. I don't even have the bundle reference.
No, it's tab 3, bundle 1, I think, is where your appendix to your first skeleton is.
Yeah.
Page 42, I'm told.
Yeah.
Yeah, the loss calculation, yeah. So your last page.
Yeah, you just see that quotation. So, I mean, I think I accept there's a bit of opacity as to how you value, and in fact there are slight differences between just doing a net present value of an income stream and doing a market sale. But broadly speaking, I accept it's the same exercise. Now, obviously, the difference is whether you take into account the finance costs. So, for example...
Yeah, well, my next question would be whether, when you ask the question, what would somebody pay for this income stream?
Yeah.
Are they assumed to pay that on the basis of borrowing the money to do so? Because I think they are normally, aren't they? You normally assume somebody buying in the market finances the purchase by borrowing money, don't you?
No, you're valuing the price. What's the price for the thing?
Yes, but in determining the price, do you assume that the purchaser's just got the cash lying around?
Yes. So if we look at the I don't really want to jump around here, but if we look at the reserve matters judgment, so this is tab 19, page 578. Tab 19, 578, paragraph 71. If you're doing a valuation that assumes that you're holding, I mean, this is, to some extent, valuers are just subservient to what we say about the law, not the other way around, but it's clear that valuers do sometimes value something for the purposes of saying what's the future net value of this as someone who holds it. And if you're doing that, you add in future finance costs. And that's our ICS guidance note, that's a different valuation method to that which was ultimately adopted, which excludes those costs. So we say, therefore, the figures used for 2021 are broadly that we saw in those tables are broadly serviceable either as a sale value or as a net present value assuming no sale, which is why they're doing different things in those situations, but the numbers probably...
Sorry, I think my point were at cross purposes.
I'm sorry, Lord.
No, it's me. Sorry. If I think we're agreed that on a simplistic level, the gross development value is arrived at by a valuer asking what would a third party pay for the income stream that this property will generate for the future and capitalising it. This property will achieve a rentals.
Yes.
In the market, right?
Yes.
Okay. In answering that question, how much would somebody pay to buy it? Do you assume that the purchaser is financing the purchase on the back of borrowing money, in which case they have to factor in the finance costs?
You assume nothing. It's what price will change hands. That's a market value.
I agree.
Yes.
But do you that will be different? The depending on the assumption you make about what a purchaser, how the purchaser will finance the payment, won't it?
Well, they may be willing to pay more or less depending on how the market's looking, because there'll be more buyers or fewer buyers, etc. And they're looking to their ultimate profit. But the valuation, so it's true that you would end up saying what yield would someone accept after they've paid their costs, and you might look at finance costs for those purposes. But these valuations, that's more about supply and demand and what you think a buyer's willing to pay based on what profit you think the buyer's minimum profit for it to work for them. But so you don't disregard them in that sense. You need to know the buyer's not going to pay too much because they still need to make a profit after they've done their financing, etc. And given the cost of borrowing, we're in a high inflation or low inflation, all of these things. So the valuers will talk about that. But the valuation, it's not true that the valuation number is affected up or down by the costs in any numerical sense. You value what they're willing to pay, given that people are very keen on property right now and they're scared of US equities and all sorts of things, demand, essentially, and your valuation report normally talks about these things. These, not so much, but that's what you get to. But it's just the price you'll pay. Whereas if you're valuing, if you're a business that just needs to put a value in its accounts and you get an investment valuation, you do the paragraph 71 version, which is you say, well, I'm going to allow for finance costs, potentially, or in any case, you have those finance costs in your books. So I think I'm disagreeing with you, and I think the judge also disagrees with you, because the judge sees the difference, and I think it's time we probably went to your table. In the reserved matters judgment, it's page, if it's the one I'm thinking of, it's 558, tab 19.
Actually, it's the one I was thinking of is the one at, start at 545.
Oh, I see, my lord. In which case I was totally wrong. We could have used that one.
Because that is the amalgam of the two.
Yes, it is. You're right. You're right. We could have used that one. But so yes, and then when we have 558, my lord is right. Apologies. 558 was the one I had in my mind, and that's the one that shows. It doesn't show the GDVs, etc. It shows your two developers' profits at row 1 and 2.
Hang on, I now need to go to one that I wasn't.
Well, you do need to, because there's more information in this one.
Yeah. This is the 558.
Yeah. So we've got rows 1 and 2. They're the profits derived from those earlier tables of taking the GDV and deducting the construction costs, including historic financing. Then you get the excess at row 3. You have my point that the dates are all wrong, because it would have to be 2021, because the net present value differs at different dates. So if my Lord Justice Snowden was saying something else, I disagree with that. The net present value is different depending the date at which you take it, because it depends first on the future income streams and what the rentals are likely to be, but also on the market information you have at that time as to what discount rate you apply and all sorts of things.
Would you compensate for the difference in timing by the rent? You would have missed out on this, surely.
No, that's not a compensation at all, because you're double counting in one way, but it also depends on how the market's moved. If your 2016 net present value is saying, I'm going to earn rent in 2016, 2017, 2018, 2019, on and on and on, the same rent that we were awarded from 2016 to 21, but then also future years, then I'm going to discount those rents to the 2016 value, depending on prevailing conditions at 2016, i.e. how attractive rental incomes are, whether the market's looking good, what discount rate I should apply, what's the uncertainty, all sorts of things that you get in those discount calculations, which we often, when you have a DCF argument, experts get cross-examined about all sorts of gammas and various things. And then if you do it in 2021, you're not discounting the 2016, 17 and 18 rents because they're historic. You're only discounting 21 onwards, but you're using the 2021 market, and it may have a lower discount rate or a higher discount rate, different gamma, etc., because it's a different time period. So it's not a matter of compensating for the time difference. The compensation would be to award the lost rent for 2016 to 21 and then capitalise 21 onwards. That would be coherent. But what's happened isn't coherent. That was the point I was making before, though. So if we just turn now to the finance.
Yeah, I still have problems with it not being coherent.
Yes,
because I think it sounds like you're doing different things. If in 2016 the world had been wonderful, the thing would have been built, you wouldn't be worrying about the fact that they hadn't lost rent because they would be getting the rent. And what would the thing be worth? The profit? It would be X. The world is never wonderful. And it wasn't until 2021. And you say, well, where are we in 2021? And the answer is, well, he didn't get 5 years rent. You say, right, give him that. What's it worth now? Not what is it worth as compared with what it was worth then. It's, has he benefited in a bizarre way out of the time, even though he's lost in another way? And that's what I thought the judge was trying to do. He was trying to say, well, yes, there's been this delay. You've been kept out of the money and you'd have had the rents. But on the other hand, because of the delay, the thing that you finally end up with when it's finally built is actually worth more. So I'm not...
Yeah,
I'm still understanding why it's wrong.
Exactly.
I understand the absolute if I was doing your exercise, but I thought in my simple way the judge was doing a different exercise.
Well, I'm going to have to run at it one more time because I still disagree with my lord, respectfully.
That's all right. Yes.
Respectfully.
Doesn't mean to be respectfully, just disagree.
Worth more in 2021 means
it can only, it's a statement that only has value by comparison.
By comparison.
Else, and therefore you say it's got to be comparison.
It's got to be 21. So what you're saying is, well, you took me out of you took me out of rental income for 5 years. So I get that.
Okay.
And then you're saying, as at the time when the development's caught up, they're both completed, have I got a more valuable development or not? That's what worth more means, and it can't mean a different date.
And you've still got to have the same data.
Yeah, that's what
see that, yes.
My lord, if you look at paragraph 36 in the table there, so what you have is the 12 million, the 10 million, the 2.5 million. We've seen those figures before. And then there's the evaluation that, based on figures that the judge finds, and there was arguments and expert evidence about these figures, the net present value of the finance costs, which are not included in the above figures, are 1.58 million for debt and 1.9 million for equity, and he found, and it's not challenged, that it was proper to take into account a notional equity cost valued in that way if you were going to take finance costs into account. So therefore, you see the figure at the bottom is negative. That means that if you are valuing the property merely by capitalizing future streams, so capitalizing the continuation of the streams that you awarded 5 years losses for in the non-breach world, you take into account the finance costs and the rental income, and the rental income exceeds the finance costs. But these are deltas. Well, the finance costs are, well, you see the deltas are the rows 3, 4, and 5. So although the income exceeds finance costs, the income in 21, the revised development, only exceeds the prior development that would have happened by a lesser amount than the finance exceeds it. So you're still making money, but you're making 959,000 capitalized of future streams less over time. So if you assume the parties are going to continue to draw rent, pay finance, run the business as it was run, then it turns out on the numbers that although you're still making money, you're net making 959 less. And therefore, there's no credit to apply. It's a negative. Now, we don't seek that negative as an order because we never claimed it, but it means that the credit should be 0, and we stick with the 4 million figure, which derives from the way the claimant formulated its claim. Having looked at the developments and compared them, which is what the defendant wanted to do, we see that the actual losses capitalized to trial date would have increased rather than decreased by taking that into account, and therefore you do nothing. But that's the appeal. And that's what it meant when, and I showed you at paragraph 55, the judge said it was slightly less profitable. That's what it means. It was 959 capitalized. This is not per annum. 959 less profitable, capitalized over its 25-year life, which I think is what the experts did. Now, I think it's probably time to turn to the reasoning although we've run through it a few times in a way. If we go back to the main judgment briefly, that's at tab 18, but it will be volume 2. It's at page 476. Perhaps I should just take you back to .474. So 474 is paragraph 673, which is the argument.
The wrong file.
After opus. It's the argument about whether the whole revised development is collateral, and that's the one at 673. And there's some detailed reasoning about why the judge thinks not. And then at 674 to 5, you have the reasoning in the original. This is the whole reasoning in the original judgment as to why you should give credit for developers' profit. And you have at 674, Bolton, I'll come back to that, although it's not clear quite what's meant there. Then 675, again, the reasoning's a little opaque, and there's a quotation from Mr. Stewart. The core point being that it's all about capital, but as I've said, that's belied by the award of the losses for 2016 to 2021, and also the evidence about intention to hold for income, etc. And then if you look at 676, you'll see in the main judgment, the judge therefore decides in the course of those two paragraphs to give credit for 2508, which to an extent I don't challenge if they were merely net present values of future rather than as deeming a sale. So the problem I have, subject to the 2016 point, which is a problem for every calculation, the problem I have is in the 676. Sorry. No, it's not that. It's the point about finance costs, which is not there at all, because it comes up in the reserve matters judgment.
Sorry, you've...
Yeah.
Too quick, sorry.
No, not at all.
So can you go back and tell me what you didn't take exception to, subject to the test?
So I do take exception to giving credit for the capital value of the development based on a notional sale because you could have sold. I don't take exception to giving credit for the future, the net present value of the future income streams, rental streams, providing one also deducts the increased finance costs that are brought back to a net present value. And that separate question as to finance costs is not covered in this judgment because it's reserved to the next hearing because there's no evidence about finance at all. So if what he means by credit is I'll credit the GDV because of a sale, well, I do disagree with that. And he does talk about diminution in value of an asset and capital. So to that extent, I do disagree. And he's got some reasoning that I'll show you in the reserve matters judgment. But if it's, as I say, the key point is the finance issue, which was actually held over because it arose in the amended reply, saying, well, if you are going to give credit for value, then you need to deduct the finance costs. And then there was evidence about those costs, and then there was a trial. And we'll see that in those reserve matters are set out in the reserve matters judgment, which is then at tab 19. So the key point decided in this sphere in the main judgment was that the revised scheme was not collateral, and that we don't challenge. But then what do you do with that? You'll see the reserve matters judgment, firstly just at 44 to 45. So that's page 563 to 4. And this is the point I've already flagged with you about RICS notes. Essentially, it's paragraph 44 is my Lord Justice Snowden's point that a buyer might include finance costs as a matter of logic, though that's not what is done here. And then paragraph 45 is that if you choose not to sell, but to let, then you do need to include finance costs. None of that affects the legal decision that we have to make. I think those are uncontroversial. But then if you get to 51, paragraph 51, which is at page 567, now, the first argument in the two arguments summarized there are is really a collaterality argument again, saying, well, it's only because of this additional finance that we got this revised development scheme. So it's saying that the profits are not attributable to a mitigation.
And you're not disagreeing
I'm not disagreeing with that.
It's the second sentence.
It's the second sentence. And the second sentence is then, so then the reasoning that follows at 53 is about the first point. And the second point is you have to go forward to 69. And if you see 69, and we've seen a couple of these paragraphs in isolation, but if you just reskim those paragraphs, you'll see at 70 we have the figures that were in that table, and those are accepted by both experts. Then at down at 73, the judge rightly says it's really about law, not valuation methodology. Then there's some argument about a point that is just to do with equity costs. And the judge agreed with the claimants about that, so we don't need to worry about that. That's through to 76. And then 77 to 78 is the entirety of the reasoning on the point now in appeal. We've seen a bit of it. And the point can be summarized as Barrowfen could have sold. And I say summarized, that's actually the point. There's not any more detail I'm hiding by doing that. That's it. Mr. Stewart points out, well, it could have been sold. And then at 78, the judge's reasoning says it could have been sold. And so the conclusion at 78.3, last sentence, that it's not a consequence, which means it's not legally caused, i.e., I think Mr. Hughes and I agree that's essentially the question of whether it's a speculation, and we know that's what we're arguing about. And that's it. So that's the reasoning. And we say that that's unsatisfactory because it doesn't engage with, it's also wrong, it doesn't engage with the facts that I've been through already, which is that it was intended to be held. It had been held for decades, earning rent. The business plan is within the parties' implied assumption of risk, which is a point I made to you before.
You're going to have to, certainly for me, you're going to have to delve into the quotes implied assumption of risk.
So all I'm saying is it's obviously not too remote because it was awarded. This is the 2016 to 21 lost profits were awarded, lost profits from renting, because they're not too remote. And all I'm doing is I'm probably misquoting the test from the Achilleas, that the reasonable contemplation test tells us what risks are within the implied assumption of the parties. It's no cleverer than that. So by it not being remote because it was awarded, and it's no good to say, oh well, no one took an objection to that. There's no appeal on that. No one says that it was too remote, and obviously the judge is aware of the possibility that a loss has to be within the parties' contemplation. And so when you're trying to improve your rental income and claiming the delay in doing so, it can't be held to be a speculation to sell. Now, it's time at 10 to 1 to look at some cases briefly. Though I'm not promising to finish at lunchtime.
Actually, we need to break it 5 to 1 on this particular occasion.
Absolutely. And can I ask what time my lords would like to finish today and tomorrow?
My starting point is 4:15.
Yes, my lord.
We see a bit how we're getting on.
I'm sure that will be fine. My lord, let's just do 5 minutes or 7 minutes on Westinghouse. There's not much to say about it. It's in Authorities Tab 3, and we've already run through these arguments a bit out of turn earlier. It's a familiar case, one of the leading cases on mitigation, of course. It's a contract case, but I don't think anyone suggests that the principles are different. And also, ours is a contract case as well, it's professional negligence, so it's concurrent. Contract and tort. You'll see from the head note, second paragraph, turbines were supplied, but they were deficient in power and economy. And the company used them for a time and then sold them. And then if we go forward to page 50 in the bundle, so this is the big number at the bottom, we see, my lords, about 8 lines up, that the claimants claim damages for breach of contract, which was the loss caused by the excessive coal used. And they wanted to leave out of account the replacement machines that they bought, which is the Parsons turbines. And then it said that alternatively the cost of installing those turbines, but they wanted to leave out of account the future efficiencies of those. And then at 52, at the number at the bottom, you'll see at the top that buying the Parsons machine, so this is from about the 5th line, he then found as a fact. This is the judgments of the Lord Chancellor Viscount Haldane. He found as a fact the purchase of Parsons machines was a mitigation. And then the second paragraph on that page, he found it was the pecuniary advantage of the respondents because they were superior. In fact, they were so superior that anyone would have bought them even if the original machines had been compliant. In efficiency and economy. And then at 53, the next page, you'll see at the middle, the judgments proceeded. profit made by using the Parsons machines had been excluded by the judge. And then we get to the decision, the opinion of the House, which is at page 59. We see that down at the paragraph at the bottom, I think the principle is that we should look at what actually happened and to balance loss and gain, this being because it was a reasonable mitigation. So let's look at the facts. And then over the page, the result had to be sent back to the arbitrators to consider the effect of these machines, because the efficiency of the machines over time seems to have eroded all extra coal in the earlier period. Now, the only point that I take from this case, I think, is quite a basic one. The claimant there the plaintiff operated a machine, a railway, and it sought machines for use in its railway. And its loss was the increased costs of using the machines. But it had to be offset by the reduced costs by virtue of the mitigatory action of the Parsons machines, even allowing for their purchase price. They were so much more efficient. And these reduced costs were a pecuniary advantage, just as the increased costs were a pecuniary disadvantage. And you have to set them off. And of course, the claimant could at any time have sold the Parsons machines. That makes no sense because they've just bought them. Or sold the original machines, or sold the business. But there was no suggestion that market value has anything to do with anything, because it was a railway business running as a railway business. I've already made the point. It's not a sophisticated one. We say this was a Tooting property holding business. That's why it was awarded damages for the loss of profits of holding that business. And you have to measure the pecuniary disadvantage post-21, if there is any, just as we've measured the pecuniary disadvantage from 2016 to 21. And that none of that deems a sale or a capitalisation or a crystallisation. My Lord, if that's a convenient moment,
Yes.
Given what my Lord said.
So, go top.